What's up, y'all? It's attorney Terry Henderson Peden, the Law Group of THP. This is Parole Attorney TV, and I'm back with more news you can use about the Alabama Parole Board as of today. And in this video specifically, I want to expose the fact, bring more light to the fact that there's no, on the books right now, there's no way or means for an inmate who's been denied parole wrongfully to go in and change or challenge the parole board decision. Not even to say to be, super jailhouse lawyer about it, but hey, man, you made a mistake. You had my file mixed up with the other person, and you set me off saying that I haven't done any programs, and I've done 27 programs, all the main required ones, right? Situations like that. So within this video, again, what I'm going to do is, okay, that's the reality in Alabama. The only recourse you have if you get screwed over in a parole hearing, or they make an erroneous decision, wrongful decision, and your parole is denied erroneously, the only recourse for that at the current moment is to file what's called a writ of certiorari, basically, which goes into the courts for them to give oversight to a parole board decision and hopefully get whatever straightening you trying to get up out that situation. That's the only means of recourse. But reason why I feel it's important for Alabama to institute some form of review or appeal process administratively within the parole board is because exactly that. A parole hearing is administrative in nature, okay? A parole board is an administrative body. So therefore it leads that you should have the person being judged, being judged within that context. The parole board is the judge, right? So the fact finder. So within that, the inmate shouldn't have to go away to an outside court. We should have some form of accountability for mistakes and common human error that might have been made on behalf of the parole board. And that's not to vilify them. That's just to say that we all make mistakes, right? So in terms of trying to do right, it's huge. I think accountability is a two-way street. I don't think that I know that. It is a two-way street. So, okay, if we're judging these people for having committed crimes, okay, and we're holding them to a very high level of accountability, okay, well, don't be a hypocrite. It ain't that hard. You know what I'm saying? So again, we could point out the problem all day, but I want to provide solutions and examples from 5 other states and processes and systems that they have in place to keep a parole board in check, and to also ensure that although the decision making is discretionary, totally discretionary, it's not a liberty interest involved because you haven't been released outside of the fence yet. That discretion is not unbridled. That discretion is not limitless, because if that's the case, the parole board in Alabama, which I think it is one of the most powerful entities. It's like up there with the Illuminati and the Bilderbergs. You know what I'm saying? Like them boys, 33rd degree Masons and all that other type of stuff. You know what I mean? So anywho, let's go through some of these other states and let's see what we can extrapolate from them and institute in Alabama to decrease this crazy overcrowding, this rampant extreme behavior by the inmates. I mean, you probably feel hopeless. Probably feel like no matter what I do, I ain't gonna get out anyway, so I might as well just do what I'm gonna do and be on this and that and whoop-de-whoop and blah, 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 you know what I'm saying? But at the end of the day, I'm trying to advocate for you to come home. So I will want you to feel encouraged about doing the right things, because it's going to actually benefit you in your efforts to get your life back outside the fence, okay? Enough interlude. That's 5 minutes. I'm finna go hard, okay? We're going to start with the state of Texas. So in the state of Texas, they have what's called a special review process for information not previously made available to the parole panel. And what that means is they provided a couple different things. So that could be responses from trial officials or victims. Say you had a pending case, you were up for parole, and you went back to court on another case and they dismissed it, and now you're up for parole. you know, or you went up for parole and were denied in the midst of being back in court on another case, right? That case got dismissed. Well, now we need to bring you back in special review so they can see, hey, this other case that was hanging over his head, which is probably a large part of the reason why you denied him, has been dismissed, right? With prejudice. So they can't even bring it back at all. That's an example of that type of situation. Changes in the offender's sentence or judgment. Again, same thing. If you go back to court and they give you a sentence reduction, that can make a big difference. If they knocked off 20, 30 years of your sentence and now you're, you know, a week later in a totally different predicament in terms of your sentence and your time that you got on you. Third, allegation that a parole panel has committed an error of law or board rule. Man, I see this so much in Alabama, and it's like, dude, it's disgraceful. You know what I'm saying? Especially, and I find it overwhelmingly hypocritical coming from people who side and identify themselves more as conservative, because their whole rhetoric is, we're by the book, we're by the code, I'm by the Bible, I'm by the statute, I'm by the Constitution. And excuse my French, my one cuss word for the day, that's fucking chicken shit. That's 2 cuss words, but it was a combo, you know what I'm saying? But it is, man, it is, because it's not about that. It's about doing what you want to do with unbridled discretion. And you black, you're not even supposed to know how to read yet. You know what I'm saying? It be that type of vibe. So for exactly that reason, I feel like Alabama needs a reason like that. They need a rule like this. Look, if you violate the procedure, if you violate the substantive nature of the metrics you're supposed to be judging me on, if you make a retaliatory type of decision against me for maybe an input made by a family member or something like that, that's inconsistent with prior voting decisions, right? Like arbitrary and capricious, right? Alarming, shocking. Moving on, parole panel, 4th reason in Texas for a special review. Parole panel denied release, but at least one member who voted desires to have the decision reconsidered. So at least one of the people who were part of the majority for the denial has said, hey, I changed my mind. Something came up. I want to rethink this. And then they can go back in and say, hey, we need to reopen this case up. I mean, that's just, there's plenty of people who got a lot of complaints about Texas parole. And in these other states, I'm sure, I'm well aware of that. However, 50% compared to currently, and there's another video coming this week, currently parole board's at 12% overall. That's violent, non-violent, men, women, overall 12% parole rate. You ain't trying. This is some modern day slavery stuff. We're going to talk about that too. Okay, so that's special review in Texas. California, you can appeal parole board decision for the following reasons. Decision was not supported by reasons or facts as stated. Again, they're looking at the wrong file, denying you based on another person named Jimmy Jackson, who has a different number. You know what I'm saying? Was based on erroneous information or actual facts justify a different decision. I've had this as well. Sometimes you got to go in there. You can't argue, oh, he's sorry, but look, man, he didn't do this. He got railroaded, and I can show you why. And you do that, you know what I'm saying? But you got to come strong if you take that approach. I be coming strong when I got it. Okay, parole panel did not, next reason, parole panel did not follow correct procedure in deciding the case, and a different decision would have resulted. Again, procedure. If you didn't give the person's attorney notice, which Alabama didn't done me like that, I had to sit in there. I got more stories. I got stories, bruh. It's egregious. Okay, significant relevant information in existence, but not known to the parole board at the time of the hearing. Again, this is the job of the parole attorney, is to go in there and make sure that you got everything prepared. You got all your bells and your whistles and your supports and all that stuff. So if I send in my packet and you don't look at my packet because the secretary never gave it to you, then you need to pay me my respect and pay my client that respect. You know what I'm saying? Okay. Conditions. Next, let me see. Conditions of parole are unfair and cannot be obeyed under the circumstances and should be amended. Okay. For example, they grant you parole and you're not a sex offender, but they have you down on a sex offender program and sex offender ankle monitor whenever you get out. Stuff happens. They vote a lot of cases. No one's perfect, but damn. No more cuss words, Terry. That's enough. Okay, New York. Now we're off in New York, baby. New York. Okay. Reason number one. Violate lawful procedure or affected by error of law. It was arbitrary and capricious, otherwise unlawful. So they just pretty much wrapped it all up. You got procedure, you got substantive. When I say substantive, procedural, you got procedural, and you got substantive. Procedural is how you're supposed to do it, and substantive is procedural is the steps. Substantive is actually what I'm looking at, right? The guidelines, the risk assessment, the home plan, the disciplinary record, right? Those things. Next, relies on erroneous information or relevant information was not available for consideration. The determination was excessive. I like this one, that it was excessive. You know, if you had a guy who's been set off 5 years, 3 years, 2 years, 1 year, goes into a parole hearing, and then you blindly set him off 5 years, that's excessive. And that's not supported according to the length and degree of a set off, right? Unless it's being used arbitrarily and capriciously, then that length of set off should match up with parole readiness. True or false? And that parole readiness, unless you have been historically arbitrary and capricious, should be indicating and coming towards from a long set off to a medium set off to a short set off to a parole vote, a grant. You understand what I'm saying? So it ain't hard, it ain't rocket science, dog. Okay. The question, and in terms of excessiveness in New York, they look at the question below may be raised on appeal, final revocation determination, some limitation, time objection. Okay. They got a whole bunch of other stuff going on. And was the determination supported by a preponderance of the evidence? You know what I'm saying? So they looking at, so within them, they have a special review or an appeals process, so to speak, and a whole panel that looks at just those requests to have something reviewed. And then they have certain criteria for that, you know, so that, again, it doesn't become administrative encumbrance or something that jams up the parole board, but something that can be used to get some straightening when mistakes have been made. Okay. Next, let's look at Tennessee. Tennessee appellate reviews may be granted for any of the following reasons: significant new information was not available, misconduct by the hearing officials, significant procedural error. So you're seeing a pattern of these things, because it ain't really that high tech. You know what I'm saying? Reconsideration. Now we're in Kentucky. So in the good old bluegrass state, if there's an allegation of misconduct by a parole board member substantiated by the record, significant procedural error, new evidence not available when the hearing was conducted, accompanied by adequate documentation. So again, if I got some heavy stuff, I got to be able to bring that and show that. If not, I'm just rambling. You know what I mean? But if I got it and you didn't look at it, that's your bad. You know what I'm saying? But I need that considered for that client, man. That's a person's life. Clearly indicate the specific misconduct of procedure error being alleged. Okay, so, man, that's it. We just went through Tennessee, Kentucky, New York, California, and Texas to give the state of Alabama a little bit better view on some changes and things that can be implemented to resolve the problem of arbitrary and capricious decision-making and the perpetuation of a modern-day slave system in which crime is being used to carry out slavery, right? And financial gain and investment opportunity for citizens and governments alike can't be cool with it, man. Free the guys. This is Attorney Terry Henderson Peden, Parole Attorney TV, the Law Group of THP. Like that there. My phone number is below. Full office contact. Hey, man, holla at me. I'm going hard, dude. Peace.